Major breaking news out of the United States Supreme Court. The Supreme Court has just announced this morning that they are going to conference the Snope versus Brown case and the Ocean State Tactical case, all in addition to the Gray versus Jennings Second Amendment case. We have to talk about what this means. This is a big step forward for the Second Amendment. Let's break it down when we come right back. Hey folks, I'm Mark Smith, host of the Four Boxer Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say a top 5 finalist in the category for top voice of the Second Amendment in America for the 2025 Gun News Awards to be held in Las Vegas later this month. Thank you for your support. All right, folks, let's get right down to it. The United States Supreme Court has done exactly what we want them to do so far, which is to schedule a conference in the 3 most important Second Amendment cases in America today. That is the Snope versus Brown case dealing with Maryland's semi-automatic AR-15 rifle ban. That is Ocean State Tactical versus Rhode Island, dealing with a quote-unquote large capacity magazine ban, which, as you know, is really just standard capacity magazines. And Gray versus Jennings, the case out of Delaware through the U.S. Court of Appeals for the Third Circuit, dealing with the preliminary injunction standards for when an injunction should be applied and when a government action should be enjoined, preventing the government from violating our fundamental right to keep and bear arms pursuant to the Second Amendment. Now, this is a big deal, folks. This is just breaking news now. As you know, last week I covered the fact that the U.S. Supreme Court had distributed for conference the legal briefs and the materials submitted by the parties and more in the Gray versus Jennings case out of Delaware dealing with Second Amendment preliminary injunction standards. This was on an expedited basis. The Second Amendment lawyers waived their full time to submit papers, and by extension, the U.S. Supreme Court agreed to conference, which means to sit around the table. And what a conference means, just to jog your memory, when the Supreme Court engages in a conference in a case, it means they all sit around a table. All 9 justices and nobody else in the room, all 9 justices and nobody else sits around a table in a room, and they vote as to whether or not to hear a case, meaning to grant cert. To grant cert means they will agree to hear the case on the merits and decide it on the merits, which is what we want. We want these 3 cases, or at least one of these 3 cases, to be granted cert on the merits. In particular, we probably want the Snope case, so we once and for all knock out semi-automatic rifle bans, AR-15 bans, AK-47 bans. There should be a layup, easy case for the Supreme Court to grant cert and decide. As to whether or not they have the fortitude to do so, we will find out in the next couple weeks. But the bottom line is that the Gray versus Jennings case was set for conference on January 10th, about a week or so ago, which is a good sign. And then we have now found out that they have conference, which means they're going to send for conference on January 10th. On January 10th, just a couple days from now, they're now going to conference, which means sit around the table and not just discuss Gray versus Jennings, but also discuss the Snope versus Brown AR-15 ban case, as well as the Ocean State Tactical versus Rhode Island magazine ban case, all on January 10th. Just to remind you, what we need is 4 Supreme Court justices, to vote to hear this case on the merits. If 4 Supreme Court justices do so, 1 or more of these cases will be heard. Now, to temper your expectations just slightly, as I've told you, what will happen, and this is what we're going to be cheering for. We're cheering for the conference. Number 1, we wanted the conference to be on January 10th. We wanted these 3 cases to be conference on January 10th. That is what we wanted. We have now received that. That has occurred. This is good. That's step 1. All 3 cases will be conferenced on January 10th by the 9 Supreme Court justices. Now, as I explained to you, if the Supreme Court is going to grant cert to 1 or more cases, here's what we're going to be cheering for. We want these cases to be relisted. Relisted, not rescheduled, but relisted. When a case is relisted, it means that they're taking the case and shoving it to the next conference to be reheard. So what we want, and I'll tell you why we want this, we want the conferences in these 3 cases to occur on January 10th. That is going to occur. Step 1, mission accomplished. Now, Step 2 is we want the Supreme Court internally on January 10th, unbeknownst to us, at least on January 10th, to agree tentatively to hear one or more of these cases. They will then publicly relist these cases, which means they will be reconsidered. The cases will be reconsidered on the next conference on January 17th. During this time period between January 10th and January 17th, if one of these cases is internally granted cert before you and I find out about it and the public finds out about it, what that means is Chief Justice John Roberts is turned to the justices, as he always does in this context, and says, look, we're tentatively agreeing to hear this case, but I want you and your law clerks to double check every procedural issue in the case. Do the plaintiffs still have standing? Is there a mootness problem? Is there a case or controversy problem? Is there some jurisdictional problem? Is there a subject matter jurisdiction problem? Basically, this is Chief Justice John Roberts' pet peeve, and he's right about this. He wants to make sure if they're going to grant cert in a case that all the procedural problems or potential problems that could pop up are resolved, because he doesn't want to grant cert in a case and then have to do all this work on it and find out there's a procedural problem that prevents the court from issuing a decision on the merits. That's a big waste of time. So if they agree on January 10th to hear the case internally, we will see a relist on January 10th, 11th or so, depending on, I guess it would probably be on that following Monday. Likely, if it's not the afternoon of the 10th, it'll be Monday morning. Those cases will be relisted, which means they will be sent back to a conference on January 17th, and potentially it could occur one more time if their procedural research is not completed in the cases, and be relisted to January 24th, which is the final conference for the Supreme Court in the month of January. Now, here's the bottom line. We need one of these cases to be granted cert in the month of January. If you and I wake up and we find ourselves like around February 1st or the last week of January, and none of these cases have been granted cert yet, we're probably SOL for hearing a Second Amendment case or for seeing a Second Amendment case this term. And it could be even worse dealing with semi-automatic rifle bans, whether or not the Supreme Court, because the anti-gunners are arguing that they should not hear Snope, they should not hear Ocean Tactical, these magazine or AR-15 bans until there is a circuit split. But as I've explained to you, and I think this is now finally well understood among the judges in America, that you're not going to get a circuit split in an arms ban case because you will never get red state-based judges in the federal system ruling on arms ban cases, because there are no arms ban laws enacted in the red states. So you will never get the U.S. Court of Appeals for the Fifth Circuit out in Texas and Louisiana, for example, ruling on an AR-15 ban case, because AR-15s will never be banned in Texas or Louisiana. You will never see 11th Circuit Court of Appeals out of Florida, let's say, ruling on an AR-15 ban case, because neither Florida nor Georgia will ban AR-15s. So you're only going to get AR-15 semi-automatic rifle ban cases arising in those terrible anti-gun blue jurisdictions of the Second Circuit in New York, the First Circuit in Boston, the Seventh Circuit out of Illinois, and the Ninth Circuit out of California and Hawaii, and so on. So, the classic argument is there's no circuit split, don't take the case, but this is unique, and I think the Supreme Court at this point is sophisticated enough in the Second Amendment to understand that dynamic. So anyway, the bottom line is this is great news. Guaranteed great news down the road? No, we still don't know what the court's going to do, but at least the ducks are lining up the way we want them. As to what ultimately happens, that's out of our control, but at least the signs are positive. So that's good news. All right, folks, hope you learned something here today. We'll be covering this story very closely over the next few weeks. Make sure you follow me on X at @4box Diner. If you're watching me on Rumble, make sure you subscribe on Rumble. Don't forget to try to also subscribe on YouTube. We're trying to get to 200,000 subscribers on YouTube. And again, I look forward to talking to all of you again very, very soon here at the 4 Boxes Diner.
Orders up. Table 2A.